Court calls the estate of Earl Samuels versus Jonathan Samuels.
This hearing begins like a routine eviction dispute, but it quickly turns into something much bigger. What starts as an argument over who has the authority to remove someone from a property soon spirals into a heated battle involving inheritance, probate court, family conflict, and accusations that lawyers manipulated the legal process. The defendant insists he is not simply fighting an eviction. He believes he is protecting his late father's wishes and preserving a family farm that means everything to him. Meanwhile, the court has a much narrower question to answer. Was the eviction legally obtained, and should it remain in effect? That difference in focus becomes the central source of tension throughout this hearing. As emotions rise, the judge repeatedly tries to separate legal issues from personal grievances, while the defendant keeps pulling the conversation back to years of family disputes and probate litigation. Watch carefully, because this case becomes less about property itself and more about whether the courtroom is the proper place to resolve these deeply personal conflicts. By the end, patience will be tested, credibility will be questioned, and one final ruling will determine whether this eviction moves forward, despite everything the defendant has argued.
Your name, sir?
Samuel.
All right. This is in effect, and just so that we're clear on the record, it would be effectively a hearing to determine whether or not a order of eviction should be entered, but that had been entered. So I'm hearing your objections and whether or not I should let that stand, sir.
Yes, Your Honor. Because it was not obtained according to proper procedure in multiple ways. If it is appropriate for Attorney Marcus as the acting for the personal representative, if it is appropriate for him to use the landlord to obtain the order of eviction, he didn't follow the requirements of the law the way, because he just tried to continue a case from nearly 2 years ago that wasn't at all the same legal entity, even though they inappropriately called it the state of Earl Samuels 2 years ago. It was actually, Dad was alive on a cell. Now Dad died, and there actually is an estate. So to come to the court, as Attorney Marcus did last month, and say that he's now the representative of the entity that obtained the order, the judgment, or the court, conclusion 2 years ago. No,
but sir, you need to understand that there are numerous occasions where there's a judgment entered by a person, being or a live person, who subsequently passes away. That case is then basically renamed with their estate, and it happens from both sides, particularly in with landlord tenant. It can happen from the plaintiff side, it can happen from the defense side. So I don't know that that's necessarily an issue for me.
well, it is, because now I'm a 50% heir, so I have a totally different legal standing than I did initially. So, and under the law, I have.
Yes, but that your standing vis-a-vis that property would have been taken care of by the probate court.
Well, that's part of my argument, is the probate court should be handling this.
No, they don't. They don't have to. As to the possession of premises, there is actually, in one reading, there's either I have jurisdiction over it, or there's concurrent jurisdiction between the probate court and this court. So either of the courts can act.
I thought it was pretty narrow, the landlord tenant law, saying that the ER in a case like this can only act to evict after the property, it says conveyed, says it's 705, 600-5407-1H. Where it's narrow in what it allows the district court to do, because
The district court can act where a personal representative is properly before the court, but the authority for the personal representative to act has to come from the probate court. I can't confer their authority to act.
well, the bottom line is that Attorney Magdis was obligated to do things in a more deliberate way rather than just try to use something from nearly 2 years ago. And you're saying that sometimes a ruling for before that can be continued on, but I would argue that because I'm a 50% heir, that
But you would have had to have gone to the probate court, right?
I'm in the middle.
Because the very fact that you're an heir to the property doesn't matter. What matters is that because there's going to be somebody that's going to be able to act regarding that property. And that's going to be the estate. And whoever is the personal representative of the estate is going to make those decisions, despite your status as heir.
One of the biggest misunderstandings in this hearing is becoming obvious right here. The defendant believes that inheriting part of the estate automatically gives him authority over what happens to the property. The judge immediately pushes back because inheritance and legal control are not always the same thing. Until the probate process is completed, the personal representative usually has the legal authority to make decisions for the estate. Whether those decisions are wise or fair is a different question entirely. Notice how the judge keeps redirecting the defendant toward probate court instead of debating every disagreement in this courtroom. That is a major clue about where this hearing is headed. The judge is not deciding who deserves the farm or whose family story is more convincing. He is deciding whether this eviction proceeding was legally proper. Do you think the defendant is focusing on the wrong courtroom, or should this judge have paused everything until probate issues were fully resolved? Let us know what you think.
If you have an objection to what they're doing, then you go to the probate court, you make your objections to the probate court to what they're doing.
and I am, and I'm in the middle of that, and there's appellate cases that relate to this. So there's many things going on that Attorney Magdis tried to go around that to involve this court by saying that he was continuing something from 2 years ago, which is significantly more complicated than he.
Did you seek a stay at the probate court to this court's action?
I filed a couple motions for reconsideration. I'm filing additional.
And the motions for reconsideration is because the probate court has ruled against you.
Right, because Attorney Magdis said things at the hearing that were not true, and the judge didn't have an opportunity to hear.
Which judge was this?
The new Oakland County Probate Court Judge Tracy Richards, who placed.
So Mr. Magdis went in, said what he said with his magic words, and just fooled the judge.
Well, she was giving deference to Attorney Magdis and my sister's attorney.
You are not going to. One thing that you're not going to do. I don't know, Judge Richards. I don't know. But I will say this. If you are, courts give deference to parties when they come in. All right. If you are going to indicate that a colleague of mine on the bench, despite being in another county, has shown some bias to your detriment. If you're going to make that argument here, the only thing I'm going to tell you is you better bring it. Because if you're going to make that accusation, you better bring it.
Well, the judge was proceeding as though Attorney Magdas and the attorney for my sister would be obligated to tell the truth. And she assumed that when she asked them direct questions, that they wouldn't say things that there's material facts that contradict. So that's all parts of my motions for reconsideration, because there are.
Has she ruled on your motion for reconsideration? Has she ruled on your motion for reconsideration? Okay, so you want this court to, so why didn't your motion for reconsideration include a stay of these proceedings?
It referred to these proceedings.
That's fine. Why didn't it include the request for a stay of these proceedings and or a request to prevent the personal representative from doing specific things until such time as the judge could consider?
I asked for multiple things in the motion for reconsideration. I don't think I used the specific language to ask for a stay of this proceeding, but I'm actually, it's 2 weeks today from the hearing.
So, sir, let me explain something to you, because built in, when I was a bit shocked when the parties appeared the last time by a number of things. One of the things that I was a bit shocked about was that you did not reside in the premises. And let me tell you why that's important. Because once the court determined what it determined here, that there had been a hiccup in trying to figure that out, the great fear for the court is that somebody was displaced from the premises to their house, and that something that happened shouldn't have happened. That harm isn't really in existence here at this time. You couldn't have resided at the premises because our order of evictions have a procedure in place that allows you to get before this court prior to the execution of any writ or order of eviction. And that is basically a 72-hour hold after the posting. That's the first thing. The second thing is that, from my understanding, there haven't been any things removed from the premises.
This is a turning point because the judge explains why he believes the situation is less urgent than a typical eviction case. In most eviction hearings, the court worries that someone has already lost their home, their belongings, or access to essential property before they have a chance to be heard. Here, the judge points out that the defendant was not actually living at the property, at least based on the evidence before the court. That dramatically changes how the judge views potential harm. The defendant immediately responds by shifting the discussion toward the vehicles that were removed, arguing those losses are financially significant. From a legal perspective, this is important because courts often weigh actual harm when deciding whether extraordinary relief is appropriate. Emotionally, though, you can already sense the defendant feels every action taken against him is part of a much larger pattern. Is the court looking only at the legal facts, or is it overlooking the personal impact of everything that happened?
Well, but there was harm. They removed 2 vehicles which had value, and I really need the money from those vehicles. So,
okay, so if you believe
that's part of the eviction.
So, okay, so if you believe that the eviction was improper, that you lost some property, then you would have to go after the estate. That doesn't come here.
What I was asking for is just to stay the eviction until we resolve things in the probate court. So.
I don't know why I do that.
Because Attorney Magnus didn't follow the procedure in several ways.
I'm giving you your hearing now. And that is precisely my point. Other than these vehicles that you say have left, and I don't know anything about the vehicles, there hasn't been the harm that would normally inure to somebody who has been evicted in this instance, because property hasn't been removed. So I'm able then to give you the hearing as to whether or not to allow the eviction to stand. And in fact, give you, as I indicated at the last hearing, frankly, more time than you would have gotten otherwise to make whatever argument you needed to make to the court.
The argument is that the probate court should control things, and if not, then
if you believe that, sir, and that this court wouldn't have jurisdiction over a property that is venued in the 14A district, if you believe that, then that argument needs to be made to the probate court to stay the eviction or to prevent the personal representative from acting on the eviction.
I'm in the middle of that process. I've been
so if you're in the middle of that process, then I should allow this to stand, and then you argue that before the probate court.
That I think there's reasons to not allow this to stand, because Attorney Magnus didn't go through the proper steps to.
I know Attorney Magnus is just a very bad individual. I get that, but that's not a basis upon which I made my decision.
Well,
I say that
he's, as personal representative, he's obligated to be impartial, and he's doing things that favor my sister.
He does. I would imagine that he's doing things consistent with his fiduciary obligation to his client, that being the estate, which there are going to be those which are involved in the estate, because it always happens, that aren't going to like that. So the real issue is you don't like what he's done.
Well, from my first conversation with him, I told him that the essential thing was that the farm stay in the family, and he said that he agreed with a basic argument that the person who was trying to buy it 6 months ago didn't have a good case to be able to continue trying to buy it. But then he changed his mind. So, and this eviction then helps him proceed with the sale that he changed his mind about he changed his mind in July. In June, he told me that the person trying to buy the farm from 6 months ago.
Who's the personal representative of the estate?
Timothy Flynn, the person that Attorney Magnus represents.
Yeah. So why do you have so much animus toward this man?
Why does he have such animus towards me? I was living at my parents' house more than half the time.
Apparently I struck a nerve. Are you listening to what you're telling me?
Your Honor, if someone
are you listening what you're telling me? Every sentence has begun with his name. He's an attorney representing a personal representative of an estate.
Yes, and he's obligated to be impartial, and
he's obligated to do his job for his client. And that's his obligation.
And that would potentially include me. I was the one who worked to create much of the wealth that still remains in the estate. It was my sacrifice for many years. So for him, he's doing things which will diminish the wealth of the estate.
And why would he do that?
Because it's quicker.
Now the real emotional conflict comes into focus. The defendant believes everyone involved is choosing speed over preserving his family's legacy. He argues that selling quickly will reduce the property's value and ignore what his father truly wanted. The judge, however, keeps bringing the conversation back to fiduciary duty. An attorney represents the personal representative, not every heir individually. That distinction matters because lawyers are obligated to follow their client's lawful instructions, even when another family member strongly disagrees. Notice how the judge repeatedly asks practical questions instead of emotional ones. Rather than debating family history, he wants to know whether the attorney acted within his legal authority. Those are two completely different conversations. This is where many estate disputes become incredibly difficult because personal expectations and legal obligations rarely line up perfectly. If you were handling this estate, would you prioritize selling quickly to close the estate, or would you wait longer to try preserving the family's wishes?
He's doing things that will resolve the estate more quickly, which is what my sister's attorney wants, rather than to achieve. I mean, for example, my parents' house is not in great condition on the outside, and I have things prepared to do work to achieve closer to full market value. But Attorney Magnus doesn't want to do any repairs and just wants to prepare it for sale as quickly as possible. So he's going to sell it to not a typical buyer, a flipper person who will.
Is he doing that against what the wishes of the personal representative are?
No, he's doing it because that's what the personal representative wants, but it's against.
Exactly.
What makes sense for the
Exactly. That's his client.
I also have an interest in the estate, and
You do. And if the decision is made that the property is sold, I'm presuming you'll get your fair share.
yeah, but my fair share of a diminished sale significantly. Imagine the difference between the
Then
house.
you have to argue that to the probate court.
Yes, I'm in the middle of arguing many things to the probate court. And
Okay.
you're saying, so a key thing, Attorney Magnus on June 30th changed the locks and my parents.
There we go.
Staying more than
He went out there himself and did it?
what?
Nothing.
He
Go
did
ahead.
it. What?
Nothing. Go ahead.
What?
Go.
Can I reply briefly?
Yeah, no, you've been very good at being quiet, so we'll let that continue a little longer. Go ahead.
So on June 30th, without any notice, without telling me that I shouldn't be staying at my parents' house more than half the time, he came and changed the locks. All my things were there. He saw that my food, my computers, my clothes, everything was there, my legal papers. Imagine if someone just came to a residence where a person's living and locked them out, and then.
But you weren't living there.
I absolutely was living at my parents' house more than half the time, and I had Google Maps timeline showing in the 100 and.
It's a different house, Your Honor. We're talking Farmington House.
So
There's an eviction
we're
case.
talking about Attorney Magnus's actions, which have been impartial, I keep referring to him because he has demonstrated, and the way he said at first that he understood how important keeping the farm in the family was to me, and how the legal argument to sell it seemed reasonable. Then he changed his mind without justification, and all of this is the whim of Timothy Fuller and Steve Magnus, rather than what's really right for the value of the estate and respecting what my dad wanted. And people refer to the estate as being intestate. There is a will. The same people who refer to no will.
Can I just say this? All of that, you've got to take me for the probate court. I told you at the first hearing, if I wanted to be a probate judge, I would have been. I'm not dealing with the will.
But
if there is one.
You're going along with what he did.
Okay, yeah. I'm going to tell you what. I don't think I've ever met Attorney Magnus before. I don't think I've ever laid eyes on him before that last hearing. What I saw as a parent, I had no idea who he was. So don't come before this court, because I know where this is headed because of the way that you make your argument. and claim that I, for whatever reason, have some bias or some other interest in what he says to me. He has said nothing in this hearing, and I see huge problems with your argument regarding this writ.
The temperature inside the courtroom has clearly changed. Up to this point, the judge has shown remarkable patience, allowing lengthy explanations and giving the defendant far more opportunity to speak than many courts typically would. But patience should never be mistaken for agreement. Here, the judge openly rejects the suggestion that he is favoring opposing counsel or accepting arguments simply because they came from an attorney. Judicial credibility is incredibly important, and judges often respond strongly when they believe their impartiality is being questioned without evidence. Notice something else happening beneath the surface. Every time the defendant expands the discussion to include lawyers, family members, probate judges, or years of past disputes, the judge narrows it back to the single legal issue before him. That difference in focus may ultimately determine this case. At this stage, whose approach seems more persuasive to you? The defendant's broader story or the judge's insistence on sticking strictly to the legal question at hand?
What about problems with the way he obtained the order from you? Because
Which I'm going through the process right now of correcting.
I would argue that the way the law is, the order isn't appropriate yet, because like the 600-547 is narrow in what it allows the district court to do as far as evictions. And I think I've cited it correctly.
When you say it's narrow, what do you mean?
Well, that's what I want to refer to is the 600-5407 has just one reference to an estate and a personal representative. And it says after, it says after sale and conveyance. Oh, I have it wrong. 5417. So here, 5714. I had the number one. 600-5714. 1H. When a person continues in possession of premises sold and conveyed by a personal representative under license from the probate court or under authority in the will. So that's when the law that let you sign the eviction order would apply.
No, sir. You need to read the other parts of the statute. That is one instance.
Well, that's the only one that I saw referring to an estate like this.
Okay.
And there is other case law. In fact, there's a case that Timothy Flynn was involved with, the state of Anderson, where they let eviction issues be handled by the probate court.
Sir, what did I say to you earlier?
You said the probate court, but I'm just asking for you to let the probate court make the decisions until it's clearly justified under 600-5714-1H for you to.
And what I'm telling you is that I'm likely to rule. And then if you believe that I am in error, you can appeal me. Or you can seek a stay of any ruling that I may enter that you deem disadvantageous to you. You can seek a stay from the Oakland County Probate Court.
This exchange highlights one of the most important legal concepts in the entire hearing: a stay. A stay is essentially the legal system pressing the pause button. The judge is explaining that even if he rules against the defendant today, there are still legal avenues available to temporarily stop the eviction while another court reviews the dispute. Notice how the judge keeps emphasizing procedure rather than emotion. He is not saying the defendant has no rights. He is saying those rights have to be exercised in the proper forum and through the proper legal process. That distinction is critical. Many litigants believe that if they feel wronged, every court should fix every issue immediately. That is not how jurisdiction works. Different courts handle different disputes, and judges are generally reluctant to interfere with another court's authority. If you were facing this situation, would you continue fighting in this courtroom, or would you immediately focus all your efforts on obtaining a stay from the probate court?
Yes, Your Honor, but you could also just have a stay to wait for some additional proceedings in the Oakland County Probate Court that
I could do it that way. I could do it that way, but I'm telling you, I'm unlikely to do that.
I'm fighting all this to try to respect what Dad wanted, and if I was never to leave the family, absolutely. This is all I have plenty of equity in other property to buy the farm. When Attorney Magnus locked me out of the place where I was living, we made life very difficult for the last 9 weeks. So I haven't been able to function very well. I mean, today I rode my bike here 30 miles because I don't currently have a working vehicle, because everything, my life is completely a mess. And Attorney Magnus, by locking me out without notice of the place where I was living on June 30th of this year, did something that most would regard as unlawful. So you're not allowed to just lock someone out of a place that they're legitimately living. Attorney Magnus tries to argue that.
You know what? You coming before me, and you just tried to besmirch this man, and you were about to, if I hadn't cautioned you, take a shot at a colleague of mine on the bench in Oakland County. Why don't you just give me the merits of what it is instead of explaining to me all the bad things everybody in the world seems to be doing to you?
I have the means and assets to accomplish what Dad wanted, and the action.
Can I ask a question? If that's all true, why aren't you making an offer on the property?
I did, and they don't want to accept it because I have to sell my properties first. So, people buy properties all the time where they have to sell their own residence first. So rather than work with me, that's why I'm so upset about everything, because people are not looking at the facts of the things, the equity that I have. It's just a matter, I could sell things as is today and get $280,000 from my West Bloomfield previous residence, or I could do a few things and get $350,000. Or I could do a lot of things and get $450,000. Next door house sold for $450,000 earlier this year. So people can put on me under how much pressure they want. Do they need me to do something today and sell the West Bloomfield house as is for $280,000, or do they want me to get $350,000 for it so that I'll have more to buy to put towards my offer on the farm? And I have other properties with significant equity also, and it's a similar story. So the personal representative, the estate doesn't have to be closed right away. I've made an offer that's higher than the offer that they want to accept. So there's, and it's just what my parents wanted, what I've always said was so essential. So why won't the personal representative or his lawyer work with me? Why did they change their mind? Why is it okay that he locked me out of the Farmington Hills house?
Okay, that's in Farmington Hills.
Yes, and I'm
Welcome to Washtenaw. I don't have anything to do with Farmington Hills.
right, but the one thing that you could do is to not allow this eviction to stand and just to wait for some additional probate court action.
At this stage, the defendant is making one final push for delay instead of outright victory. He is no longer asking the judge to decide every probate issue. Instead, he simply wants time. From his perspective, delaying the eviction could preserve the opportunity to buy the family farm and keep everything intact while probate continues. But from the court's perspective, delay without sufficient legal justification can create its own problems. Judges must balance fairness with efficiency, and they cannot simply pause cases because another related dispute exists somewhere else. Listen carefully to how the judge answers. He does not completely dismiss the defendant's concerns, but he also refuses to promise relief simply because another case is pending. That is a common reality in litigation. Parallel court proceedings often move forward at the same time. Do you believe the judge should have pressed pause until probate was resolved, or was it reasonable to let both legal processes continue independently?
Because that's really what controls things, as you've said.
Oh, I don't think I said that entirely.
I'm sorry.
Okay, have you finished with your argument?
I mean, there are other cases where the probate court was the one that made decisions about landlord-tenant issues where it's not really falling under the landlord-tenant law. Because of my interest in the property, the way as 50% advisee, title will ultimately, if it goes to me, will ultimately be backdated to the day of dad's death. It's like title transfers at the time of death subject to administration. So it's not a typical landlord-tenant case, and there's other case law that supports that. I just haven't had time to prepare things for you.
As I said, you've been given way more time than most individuals coming before this court.
Considering that I'm struggling with the probate court, so many filings, and the appellate court, and my unstable living situation, I would argue that I could be given a little more time.
Anything else?
I just think that the court is letting, as with so many things that happen with probate court involvement, the lawyers have sort of gone around the rules, and it's
So now you're accusing the lawyers of going around the rules and the court's letting them.
well, by signing the order of eviction when it really had.
Okay, well, let's get this clear. Signed the order of eviction, stayed it, had a hearing, gave you additional time once I found out that it really wasn't a residence and things hadn't been removed, and now we're here today. So if you want to talk procedurally, while it is unusual, if you want to talk procedurally and any detriment to you in that, it's not there.
Well, I have been harmed by the removal of my vehicles, and that was a part of the eviction proceeding. He removed the vehicles. the eviction server person required that the vehicles be towed before he would do his eviction and break into the house. And they did take things out of the house and damage some things. And I haven't analyzed what they damaged because I had been living there.
Well, before you told me they had.
What?
Before you told me they had.
I never said they hadn't damaged the house. They broke into the house and threw a bunch of things out on the lawn, and I put some things back on the porch. But they.
Is there anything else you want to argue to this court?
I mean, there has been harm, and the harm came after they misrepresented to the court that they were entitled, that the PR and his lawyer were entitled to have the order of eviction signed by.
Sir, there's a big difference between doing something and misrepresenting something. And, you know, I'll be honest with you, I'll listen to you but I'm not going to allow you to just come in here and just smear everybody that seems to come in your path. Because that's all that you're doing.
This is one of the strongest moments of judicial control in the hearing. The judge is no longer debating statutes or jurisdiction. He is addressing courtroom conduct. Throughout the hearing, the defendant has repeatedly accused attorneys, family members, and even another judge of acting improperly. Whether those allegations are true or false is not the issue at this moment. The judge is reminding everyone that serious accusations require evidence, not repeated assertions. Courtrooms operate on proof, documentation, testimony, and legal standards, not simply frustration or personal belief. This is also a subtle credibility issue. When someone attributes every setback to bad faith by everyone around them, judges often become more cautious about accepting unsupported claims. That does not automatically make the defendant wrong, but it does raise the burden of persuasion. Have you noticed the judge becoming noticeably firmer as the hearing progresses, or do you think he has remained consistent from the beginning?
People are going to disagree, sir. Part of the reason we're here is because people disagree. And I have to make a decision, but it has nothing to do with anybody personally. For me, it doesn't have to do with any of that.
But the actions of Attorney Magnus did have very real consequences for me over the last several months since his involvement. I mean, mainly with the Farmington Hills house and with his changing his mind about the sale of the farm and trying to get the farm sold rather than have me be able to buy it. So he has made arbitrary decisions, him and Timothy Flynn, which have
they can be as arbitrary as they want. As client, they can be as arbitrary as they want.
I would argue not. I would argue that the law.
Okay, you can argue that. I'm telling you, they can be arbitrary regarding certain things that they want to do. They don't have to operate on your moral guidelines.
Well, the law is very clear that they're supposed to be impartial and not do things that benefit the favor of one devicee over another.
Then that you need to take up with the probate court if you believe that that's happened.
I absolutely believe it's happening, and I absolutely am taking it up, and that's part of the reason.
Then that's where that argument belongs.
That's part of the reason I need more time here, because all of this helps to speed along what should have been more deliberately handled in the probate court.
Anything else?
What remedy is there for the harm that's been done by Attorney Magnus having my vehicles towed, and that was only because of the August 21st order that you signed when Attorney Magnus implied that he was continuing, we've discussed. What remedy is there for the harm that I suffered? And there is a harm to the,
What kind of vehicles were these?
it's a 2002 Pontiac Grand Prix that was functional, it needed a new fuel line. That's,
A 2002 Pontiac Grand Prix.
yeah, I mean, it's not worth much.
The other car, what's the other
I
vehicle?
submitted pictures, Your Honor, of the vehicles when we told them.
The other car is a 1990 Honda Civic, which is actually worth more than the Grand Prix, even though it's not functional.
Yeah, that's people judging what American cars are worth. Go ahead.
Well, it's because there's some like, people, fans of a movie, people like this old model Honda hatchback, and the engine in my Honda Civic has only 100,000 miles on it, and there's other parts. So I've seen ones that are just like a shell for 1,000 or more. So my car with significant parts was worth over $1,000, the Civic. And
Okay, so it's $1,000. And then how much is the other one worth? It's a GM, so it's not much. I'm a Ford guy.
the other one was worth between 500 and 750, whereas scrap value.
So we're talking $1,500.
I would say the Civic is actually worth more than 1,000. I said 1,000 for a
How much are you, how much are you saying?
$2,000.
2,000 total. All right. Anything else?
Briefly, Your Honor, with the most recent,
You may take whatever time you want. You have been very patient and listening. Go ahead, sir.
I won't take long. You and I think see the same case in the exact same way. I'll just say we're the latest in a long line of judges and attorneys engaged with Mr. Samuels in the exact same way. We have, I think, 7 other eviction cases. There's 9 appeals, maybe 10 pending court of appeals with regard to, this goes back many years. The point being, I did put the court in this position by missing that 56-day court rule.
After hearing more than 38 minutes from the defendant, the courtroom is finally about to hear from the opposing attorney. This is often where viewers expect dramatic new evidence or an aggressive rebuttal. Instead, watch how differently the attorney approaches the situation. Rather than matching emotion with emotion, he focuses almost entirely on procedure, timelines, and practical facts. That contrast is striking. One side presents a broad story stretching across several years of probate disputes and family conflict. The other side narrows everything down to whether the legal requirements for this eviction have ultimately been satisfied. Even more interesting, the attorney openly admits that an earlier procedural mistake occurred. In many courtrooms, acknowledging an error can actually strengthen credibility because it demonstrates candor rather than defensiveness. The judge immediately notices that honesty. Sometimes admitting a mistake can carry far more weight than trying to explain it away. Were you expecting the attorney to respond this way, or did this surprise you?
And can I just stop you there? Because, and I think it's important to point out, as this gentleman has been sort of smearing you, one of the things, and I remarked it to my staff when I went back, Rick, and that is that you came in, and for somebody that's looking to hide stuff or do whatever, the shady stuff he says you're doing, you stood before this court, said, look, Judge, I wasn't aware of this. I did this. This is what I did. Just straight up. And I'm going to just tell you this, Judge, I appreciated that. That's how lawyers practice. Go ahead, sir.
Thank you, Your Honor. Yeah, so like I said, at the last hearing, I learned that one in real time, right? So we could have had this hearing 2 weeks earlier. But as you said, the result's the same. Mr. Samuels doesn't live there. We removed his cars. Yes, they're waiting at the impound for him to pick up. No problem. And I just asked the court issue the order so we can move this whole process forward.
All right.
Yeah, they want a lot of money to pick them up, so that's, and it's, I have another property a mile away that if he worked with me, we could have put my cars at my other property a mile away. Now they're somewhere 20 miles away, and it's.
Or if they were drivable prior to this happening, you could have moved in there.
Yeah, they weren't drivable. The driveway needed
Okay,
to go
then you
by.
could have gotten a tow and got him there.
Exactly, a mile would have been an easy, cheap tow, but Attorney Mondes didn't work with me. didn't contact me.
You know, I just
And,
hook into my truck and drag it up. I'm kidding. Go ahead.
well, no, I actually could have done that. To take him down.
So why is that his fault?
Because he didn't let me know that he was.
Because
leaving.
everything is his fault.
There was no reason for me to think that he would tow the cars in August.
Okay.
There was no reason for him to have done that without notifying me. He gave me no notification at all. And he was notifying me of other things. He refers to evictions and all. The bottom line is that when I was conservator, I did for my family what anyone would want a conservator to do. And I was only removed as conservator 2.5 years ago because other attorneys said things in court, material facts that are absolutely not true, that the judge even acknowledged when seeing video.
Oh, so these were other lawyers that lied?
By now, a clear pattern has emerged, and the judge is openly recognizing it. Nearly every explanation offered by the defendant circles back to another person who allegedly acted unfairly or dishonestly. The judge repeatedly redirects him because those broader allegations are pulling the hearing further away from the actual legal issue before the court. This does not necessarily mean the defendant's experiences never happened. It means this courtroom is not the place to relitigate years of probate disputes, conservatorship disagreements, or family history. Judges have to separate emotionally compelling narratives from legally relevant facts. That is often one of the hardest parts of any courtroom proceeding. You can also hear the judge becoming increasingly direct whenever the discussion drifts into accusations without immediate relevance. The closer this hearing gets to a ruling, the less patience remains for arguments outside the scope of the case. Based on everything you have heard so far, how do you think the judge is about to rule, and why?
No, it's again, my sister's lawyer is the main.
Oh, okay. All right. I'm just trying to get it clear.
Well, my sister's lawyer has misrepresented material facts many times.
Okay. There we go again.
She has.
Okay.
Can prove.
Okay, that's fine. Is that before me?
Attorney
Is it before me?
all these-
Is it before me?
In a way, it is.
Why is it before me?
Consequences of it are before you. All of this has happened because from the beginning, I did what anyone would want as conservator. And instead of it being applauded, I markedly increased my parents' wealth. I did everything the way Dad wanted. I cleaned up their house such that the judge, seeing the video, said, yes, it does look good. But the attorneys for other sides said, I didn't do what I did, even though they had video, a proof, and later acknowledged that I did what I said I'd done, but they hadn't believed me. So it is before you because the consequences of everything that's gone on in the last 4 years lead us to where we are. So this is just the final action in a terrible sequence of events, which started with my sister betraying my parents when they were clear on what they wanted for the future. And both my parents died prematurely without me caring for them because of the probate court involved. And it's obviously sounds crazy, but it is.
No, it just sounds like another one of your attacks on somebody else. That's what it sounds like to me.
So when Dad was saying he wanted me to keep caring for him and I was having him gain weight and they took him away from me, it's my
Sir, then all of that has nothing to do with this case.
Indirectly, it does because it led us to where we are. It's like there should be, my dad's will said the PR would be my sister and me. We only have an independent PR because of actions by my sister's lawyer 2.5 years ago that I didn't even understand.
Then you need to bring that to the probate court. I can't do anything about that. Even if, for whatever reason, I thought you were right, and I have my serious doubts as to whether or not you are, even if I had my doubts, there's nothing I can do.
Well, you could just do nothing rather than enter the order of eviction.
You haven't been here before. It's rare I do nothing.
Well, in a case where there's some question as to.
No, I really don't have a question.
There are some appellate cases relating to the district court's involvement in estates and landlord tenant issues.
If you believe that my action is inappropriate, sir, you have all of your appellate rights.
I'm already completely overwhelmed with what I'm trying to do.
Whether or not you choose to exercise those rights is beyond me. But you will have them.
I just,
And unless there's anything else, I'm ready to rule.
I understand that, and I just think that, you're, as with everyone, respecting the lawyers instead of analyzing actions that they've done. Like,
Sir, you know what? I'm gonna stand in recess. I will come back. I promise you I will come back, but I don't want to say anything that's gonna get me in a whole bunch of trouble.
All right.
You may be seated. I told you I'd come back.
The judge's brief recess speaks volumes. Experienced judges rarely step away in the middle of delivering a ruling unless they recognize emotions are beginning to influence the moment. Rather than responding impulsively, Judge Simpson pauses, regains composure, and returns ready to explain his reasoning carefully. That decision reflects an important part of judicial professionalism. Courtrooms are not only about reaching the correct legal outcome, but also about ensuring that the process appears fair and measured. Throughout this hearing, both sides have expressed frustration, yet the judge has consistently attempted to separate emotion from law. Now comes the most important part of the case. Everything said over the past 45 minutes will be condensed into a legal ruling based on evidence, procedure, and jurisdiction, not sympathy. Regardless of which side you support, this is the moment where courtroom advocacy ends and judicial decision-making begins. Pay close attention, because every reason the judge gives will explain why he reached his final conclusion.
The fear of saying this, is there anything else from either party before I rule?
Okay.
Sir?
just, please try to understand.
Oh, I do understand. And I've listened to almost 45 minutes of your argument. And at each point, frankly, and just to surmise that you were always blaming somebody else for doing something to you and then attributing some evil motive to why they were doing it. And it's all because things didn't go in your direction. In this case, counsel freely admitted that there was a violation of the 56-day rule. However, this court determined that there really was no harm that inured to the defendant because of that. And the reasons for that are, number one, the defendant did not reside in the address. Number two, property was not removed prior to the defendant filing what I'll call his motion before this court so that he could be heard, with the exception of 2 vehicles.
Here, the judge begins laying out the legal foundation for his decision, point by point. Notice how methodical the explanation becomes. Instead of revisiting every accusation or emotional argument, he focuses on concrete findings that directly affected the court's analysis. First, he concludes the defendant was not residing at the property. Second, he finds that personal belongings were largely not removed before the defendant had an opportunity to challenge the eviction, with the exception of the 2 vehicles. Courts frequently evaluate actual prejudice when deciding whether a procedural mistake requires overturning a previous order. The judge is essentially saying that although a procedural issue existed, it did not produce enough legal harm to justify undoing the eviction. Whether viewers agree or disagree with that conclusion, this illustrates how courts often distinguish between technical errors and errors that materially change someone's legal rights. Do you think procedural mistakes should automatically invalidate an eviction, Or should judges also consider whether meaningful harm actually occurred?
It's also come out during the course of this hearing that despite that, defendant had access to those vehicles in the sense that he could have paid for those vehicles and retrieved them, did not, and chose himself to not do that.
Because of lack of money.
Okay, I've let you talk for whatever. It is my time. Am I clear on that? And all of that having been said, while this is unorthodox, this court does believe that it preserves the protections that the 56-day rule, the two 56-day rules actually, have in place, and the intent of those rules, so that stale orders and other things don't happen. The defendant has had an opportunity, certainly, to be heard before this court on the first occasion, back on September 3rd. The court heard the initial part of this, gave the defendant additional time, which he did not use to provide anything in writing or otherwise to the court regarding this particular proceeding. And it seems that his major beef has to do with the actions of the personal representative, counsel.
This may be the clearest summary of the judge's perspective during the entire hearing. After listening for nearly an hour, he concludes that the defendant's primary dispute is not truly about the eviction itself. Instead, it centers on disagreements with the personal representative, opposing counsel, and decisions being made in probate. That distinction is significant because courts can only decide the issues properly before them. Even if the defendant sincerely believes the estate is being mishandled, that alone does not necessarily invalidate an otherwise lawful eviction proceeding. The judge also addresses something many viewers may have noticed throughout the hearing: the repeated attribution of bad motives to nearly everyone involved. Judges generally require evidence of misconduct before accepting claims of bias or intentional wrongdoing. Personal conviction alone is rarely enough. As the ruling becomes inevitable, ask yourself this question: has the defendant successfully challenged the legality of the eviction, or has he mainly demonstrated dissatisfaction with broader probate decisions?
The court and everything else, and I guess prior to my going off of the bench, he, quite frankly, had not, as of yet, taken a shot at me, and it was about to, and so I certainly needed to remove myself before I responded back, and may have responded back in an inappropriate fashion. But you can take whatever shots you want at me. I'm sure in whatever other hearings, my name will come up as somebody who has done something wrong to you. I don't think that I have. So, having said all of that, it is the order of this court that the order of eviction will stand.
And there it is, the decision everyone has been waiting for. Judge Simpson rules that the eviction order will remain in effect. However, notice that the ruling is not simply a victory for one side without explanation. The judge carefully outlines why he believes the procedural safeguards were ultimately preserved, despite the earlier issue involving the timing requirements. He also grants a 7-day delay before enforcement continues, giving the defendant an opportunity to seek a stay from the probate court if he chooses. That additional time is significant because it preserves another legal option without preventing the district court from moving forward. In other words, the judge is saying, my decision stands, but the legal system still provides you another avenue if you believe I am wrong. That balance between finality and appellate rights is a fundamental feature of the judicial process. Would you have ruled differently based on the evidence presented during this hearing?
And that the execution of the order of eviction signed by this court may continue. The defendant may seek a stay if he wishes. This order to give the defendant an opportunity to seek a stay before the Oakland County Probate Court this order will take effect for the continuation of it 7 days after the signing of my order. Thank you.
Should I submit a proposed order?
I really like having you guys here, but I'm going to do an order. All right. So if you want to wait, she's beginning that and should have it for my signature shortly. Thank you.
This case ultimately came down to a simple legal question wrapped inside an incredibly complicated family dispute. The defendant argued that procedural mistakes, probate issues, and the personal representative's actions should prevent the eviction from moving forward. Judge Simpson disagreed. After reviewing the arguments, he ruled that although there had been a procedural issue earlier in the process, it did not create enough legal harm to overturn the eviction. The court therefore allowed the eviction order to stand, while also giving the defendant 7 days to seek a stay from the probate court if he wished to continue challenging the decision. Whether viewers agree with that outcome or not, this hearing demonstrates how courts separate emotional family conflicts from the narrow legal issues they are authorized to decide. The probate battle may continue, but this chapter has officially reached its conclusion.